Hi, this is Kunal Srivastava from Diorama International Film Festival. Today we have a session on protecting IPR in cinema, which is a very hot topic and a very important topic these days. So I'll just introduce Ms. Carlyta Mouhini. She's an advocate practicing in India and Spain. And I would like to hand over the session to her and introduce our speaker. Please go ahead, Carlyta.
Thank you, Kunal. And good evening to all our viewers who are with us tonight in the Diorama International Film Festival in New Delhi, and also on behalf of the eminent legal panelists of our country, India, and the ones who came from the Indian soil. I would like to thank you to have been able to contribute your time for different time zones in the world regarding the discussions on intellectual property rights and IPR in cinema, as is known as IPR, and definitely the Indian perspective in international jurisdiction. Welcome, and I am honored to introduce today's eminent legal panelist. First, our speaker is Ms. Rashda Rana SC, then is Mr. Hulb Berndschot, then Mr. Nilanjan Sen, and Mr. Josh. So we open this entire session with Ms. Rashda Rana SC. Now, and I must introduce her in a wonderful wide perspective. Ms. Rashda Rana SC specializes in commercial law and works internationally as counsel and arbitrator. She has represented a number of challenging players in the film industry around the world, from United Kingdom to Australia. Ms. Rana is well renowned and sought after counsel in the legal fraternity of our industry. The first question, Ms. Rashda Rana, good evening to you once again. Considering your extensive experience in the field of intellectual property and dispute resolution, what would you suggest are the best ways to protect your intellectual property in film industry in the United Kingdom?
Thank you very much, Carlyta. And I also just want to thank all the organisers for inviting me to speak on this topic today. I want to just set out a little bit of background in terms of what happens in the UK. The UK provides, in the UK, what is provided for is that original work is copyrighted, and that copyright arises automatically as soon as the work is created and fixed in a material form without any need for registration. So this is the position universally. And it's important to note that ideas are not protected by copyright, but only the expression of those ideas as they are fixed in the material form. So that's, for instance, a film. Under the United Kingdom and European copyright, and I'm sure Hulb will deal with that, the joint owners of copyright in a film or a television program are usually the principal director and the production company or broadcaster who arrange for the work to be made. This means that every finished audiovisual work has usually two joint authors who each own copyright when the work is created. So copyright does not exist in the idea, remember, for a creative work or a film, only in the finished work. I've had some matters where somebody's pitched an idea which has then actually been developed and made into a film or a series by somebody else. So it wasn't the idea that was protected, it was ultimately the finished work, the film or the television series. So, for instance, directors in the United Kingdom have the right to be identified as the author of the film under the legislation in England, which is the Copyright Design and Patent Act of 1988. The scriptwriter, director, cinematographer, lyricist, composer, and other authors of a film also have certain moral rights, and we'll look at those moral rights, no doubt, later in our session. So infringement can be in relation to the whole or a substantial part of the work, and a substantial part of the work has been copied if the infringer has taken the author's intellectual creation. So substantial is determined by a qualitative test, not a quantitative. So it's not, you copied 10 minutes of it or whatever, but really whether you copied the essence of the work, which means that there may be an infringement even if a small but important portion of the work is copied. So in addition, an individual or a corporate entity may actually commit a secondary infringement of copyright if, among other things, they import into the UK, for instance, or possess, sell, or distribute an article which they know or have reason to believe is an infringing copy. Lately, I've had to deal with infringement of computer programs. So computer programs are regarded as literary works, and therefore at a very basic level, their protection is no different from any other literary work. However, with the development of ever more advanced technology and AI generally, this area is becoming an increasingly contentious area. Some years ago, the more significant area that I dealt with was actually music. And it's not only in Bollywood movies that music, both in the song and dance variety, but also the incidental music that plays such an important role in evoking the vibe, the atmosphere, and mood. Now, all of that must be licensed in one way or another before it can be used. So it can be any bit of music, including an actor singing a song or humming a song. And all of this really needs to be licensed. And this can be one of the biggest problems, I think, faced by producers, for instance, and consequently distributors around the world. And I've learned through one particular matter that I dealt with that changing out music in a film can be very, very expensive. So given the very public nature of film distribution and the sophistication of companies that control music rights, actually one of the most well-developed areas of creativity, the probability of getting a claim for failing to clear music is nearly 100%. So you really must ensure that every little element that you use has actually been licensed, because it's a very valuable right that you need to protect. I'll just mention in passing that you may have heard recently that Bob Dylan, for instance, sold his entire catalogue of about 600 songs and for about $300 million US dollars. And that's the sort of right that you have to protect. I'm sorry, am I running out of time?
No, you're just fine. This is very important juncture. Very important part.
Thank you. And I just wanted to mention two other players in this field who are buying up music catalogue.
This is what people want to hear. This is what they want to hear.
Yeah, so I mean, you've probably all heard of Universal Music Publishing Group, and they're the ones who bought the Bob Dylan. There is another independent publisher and marketing company which is buying up music called Primary Wave. They've really been coming up in the last few years. And in the UK, there's one called Hypnosis Songs Fund, which also has bought up quite a lot. In fact, it spent nearly $700 million US dollars acquiring songs from, I think, about 45,000 songs from different artists such as Blondie, Barry Manilow, Chrissy Hines, and many others. So this really means that the artists who have sold on their rights no longer have power to veto or to prevent the work being used in any particular way. So they've actually given up that very important right, as well as, of course, the economic consequences of that right, which is they no longer will be entitled to royalties for that music being used. And one important bit that that I wanted to mention is Brexit, because how is Brexit going to impact the copyright world? So as you know, copyright is territorial, and even in the European Union, there is some harmonization, but not full harmonization. So the scope of protection for copyright works in the UK and for UK works abroad should largely remain unchanged. Since most of the UK law is derived from EU directives and regulations, it will be preserved. So the government actually will, in January 2021, with or without a deal, bring in legislation that will convert all EU directives and regulations to law, take out references to EU and bring in references to those components being English law. So ultimately, I think the works both here and artists' works being used abroad should remain constant and should remain protected.
Thank you. Thank you so much. And I'm sure that the second question, which goes on to you, is so much, in relation to the first one, which you said. As you see, that in the present day and age, the IPR has gained immense importance. You see, everything which surrounds us, be it a movie, a song, a video game, as you said, the licensing between Bob Dylan, and it reminds me Michael Jackson when he wanted to buy the whole thing up from Elvis Presley. That is also an ongoing thing right now. And then everything is intellectual property. Everything is every smallest part belongs to anybody, to somebody. Now, film production comprises of intellectual property at each stage. Seeing this immense growth of international property, what are your views in protection of IP in the modern world? In this
Well,
today,
Carlyta, it's interesting that, well, certainly recently, again, with technology, we've seen immense growth in what is available to us in terms of particularly entertainment and therefore the finished creative work. And therefore, the flip side is we've seen an immense growth in IP rights as well as IP cases. I'd worth mentioning that the World Intellectual Property Organization's report from last year, which was actually just published a couple of weeks ago, shows this very element in terms of trademarks and copyright cases, but shows that patents have gone down, and that's partly due to the Chinese patents being a reduction in Chinese registrations. But the issue of IP rights, interestingly, is not a new one. So most of your audience, I think, will be aware of the Berne Convention on the Protection of Literary and Artistic Works, which actually came into effect in 1887 and currently has about 179, 180 signatories. So that's 179, 180 countries that have signed up to protect literary and artistic works in each of their jurisdictions. And then incidentally, it was set up on the urging of Victor Hugo. So you'll remember Victor Hugo from the 19th century, a very famous French author. But before that, the statute of monopolies in the United Kingdom goes way back to 1623, and that was actually used to abolish government-sponsored dominance of guilds. So people who had an artistic endeavor joined guilds, and the guilds then actually owned the copyright of their works. So those industries, that whole notion was eventually abolished, and the legislation vested intellectual property rights in the creator of the work. And then 100 years later, the Statute of Anne in about 1710 brought in initial protection periods for those works. So that it was very small then, it was 14, 15 years, with a renewal period after that of about another 14, 15 years. So we are actually talking about rights that have been around and in fact enforced by law for a very long time. And it's you're quite right that now what has happened is there's been an explosion of it because of the nature of the works that are being produced. So again, the most important thing about IP is that it protects your work and stops others from using it without your permission. And copyright gives the authors of works rights to control the use or commercial exploitation of the works that they have created. And it includes the exclusive right to copy, issue copies, rent or lend, perform, show, play, communicate the work to the public or adapt it in any way. And the right also stops others from doing any of these without your consent. So that is the hugely important part of intellectual property. So it gives you total control of your creation. two other aspects worth noting, and they're not necessarily modern in that sense, but important parts of copyright are moral rights and economic rights.
Right.
And the concept of moral rights also exists nearly everywhere in the world. The common law systems tend to be most concerned with the economic aspects of ownership and exploitation, whereas, and I'm sure Hulb will comment on this later, civil law systems tend to emphasize the principles of natural justice and individual rights, particularly the right to ongoing control of the creative work. And of course, as I mentioned earlier, the Berne Convention deals specifically with this area and has various automatic rights. But there are a number of what might be termed key universal principles that apply to works, and they can be encapsulated succinctly, I think, in a number of punchy points that I think most of your audience would understand. First is, of course, exclusivity, what I've just said, that the authors or rights holders, so these are people who might own the copyright, have right to decide whether to authorize or prohibit certain use of a copyright work by a third party. The other one is that there are no formalities of establishment. So ownership of copyright exists from the time of creation and doesn't require any formal registration, although there are many organizations so directed at particular groups of people which will register what you've created, but there are no formal registration requirements. Although I think in America, in order to recoup financial recompense, you do need some sort of registration. But again, Josh can deal with that element of it. Yes. Thirdly, there's the contractual freedom. So authors and holders of rights can define exactly the terms and conditions under which they'll grant exploitation rights to their work. So how my work will be used, and put very strict parameters around it. And so, you know, an example is, for instance, J.K. Rowling with all her works, the Harry Potter works. She had very strict requirements, not just in the filming, but also in the merchandising and so on. So that was, you know, part of the contractual arrangements she could enter into as a result of her being both author and rights holder. Then, of course, remuneration, the rationale behind a copyright law is to stimulate artistic creation, of course, by providing an equitable remuneration and acknowledgement of the creator's efforts to produce literary or dramatic or musical artistic works, and of course, including films. And as film industry all over the world must have felt this year, the fact that you can still get royalties for your efforts, even though you're not working, has become a very important part of keeping the film industry afloat. So it's a very important element of the key principles behind copyright. Then, of course, territorial, I mentioned that a little bit earlier, the author or the rights holder, of course, can decide on the geographic scope of the license that it provides the third party. And then lastly, none of these rights would have any teeth if you couldn't enforce them. So the author, again, or the rights holder, can enforce his or her rights against any unauthorized work. So given, and we'll come to how you might enforce it, whether in litigation or in arbitration in another question, but given that copyright arises automatically, it's always good practice to keep records and evidence of any materials or work created and when, a sort of an audit trail, which you may need to establish the subsistence and ownership of copyright in any infringement proceedings. I just want to mention the difference between what I've been talking about in terms of authors' rights and moral rights, because moral rights sit in a slightly different basket, and they are really a collection of personal rights which are allied to copyright. And those rights are given to authors of literary, dramatic, musical, films, artistic works, directors of films. And these rights include the right to be identified as the author or director whenever the work is commercially published or exhibited to the public or included in a film or any broadcast, and that's sometimes known as the paternity right. Then there's the moral right to object to derogatory treatment of your work. So that's the right of integrity. So, for instance, if it's used in Saturday Night Live, you have a right to object to that.
Right.
Then there's the right not to be identified as the creator of a work created by someone else. And this is false attribution. When you say it isn't me, so stop saying it's me. That's actually another moral right. And the right not to have copies of your works exhibited or broadcast or issued to the public. So this is the right of privacy. And many people will have come across the right of privacy or the right to be forgotten in the context of Google searches. And so this is falls within that sort of ambit of moral rights. But moral rights belong to the author of an original work, and they can be waived, but you can't assign them. But importantly, they remain with the creator of the work, even if the copyright does not. So in many contracts, not just films, but other areas, I've seen them in commercial contracts, right through every industry, including, for instance, construction. There are clauses that require the contractor or the other party to warrant that they are not actually treading all over somebody's moral rights, or if they have, they have got permission to do so. And then one final element that I think perhaps is worth noting in this context of where we find ourselves in the modern world is the distinction between the meaning of authorship and copyright ownership. So I've been talking about author and rights holders. And so authorship, of course, refers to the status of the person who created the work, whereas copyright ownership defines the legal status of the person or entity, because it could be a company, that has acquired the exclusive right to exploit that work. So if I go back to Universal Music Group, for instance, they've now acquired the rights of Bob Dylan's works. So they now have the exclusive right to exploit that work. And in most countries, contractual agreements will certainly clarify the specific circumstances of ownership of copyright. And these circumstances will, of course, include works created by an employee. So there are many settings in which the creator has given up that right of ownership to his or her employer. For instance, in commissioned works or works created collectively by several people. So depending on the jurisdictions, the initial owner of, say, a film could be either the producer or a single purpose entity, most likely controlled by the producer. So in every element, I think, of especially the film industry, the protection is, again, an extremely valuable asset to have, whether you're the owner or you become you're the author or you become the owner of that copyright.
Thank you, Rashda, because there's so many elements which you have simplified in a very simplified way. You have discussed it. Now, considering that with the author's right and moral right, and all these various aspects in IPR, and what do you think the scope of arbitration? In such disputes involving infringement of copyright, as you mentioned earlier, but in a broader form, involving the infringements of copyrighted works.
Yes, yeah. Carlyta, this is very interesting because arbitration, again, like IPR, has been, had an exponential growth over the last 20, 25 years around the world, particularly with the increase in trade has resulted in cross-border jurisdictional issues being best dealt with through international arbitration. And the question of whether a particular subject matter could be a matter that could be resolved by arbitration has affected every area that you can think of. And of course, it has arisen in relation to IP disputes as well. And because IP rights such as patents are usually granted by national authorities, it had been argued for a very long time that disputes regarding such rights should only be resolved by a public body within a national system, so either some sort of tribunal that dealt with IP issues or indeed courts themselves. But now I think it's right to say that it's broadly accepted that disputes relating to IP are arbitrable, so can be the subject of arbitration, just like disputes relating to any other type of privately held rights. So the principle is that any right of which a party can dispose by way of settlement, so by agreement or by negotiated settlement or by decision making, should in principle also be capable of being the subject of arbitration, because arbitration, like settlement, is based on party agreements. It's a creature of contract, and therefore it can be subject of another creature of contract, being arbitration. And so, as a consequence, the consensual nature of arbitration means that any award rendered by an arbitrator will be binding on those parties involved and will not affect other rights. The types of IP disputes that have been the subject of arbitration, I've certainly dealt with quite a few, include patents, trademarks, copyright, design infringements, disputes relating to database rights, domain names, misuse of confidential information, trade secrets, and incidentally, one of the first areas that actually dealt with IP rights was trade secrets. So I'm talking about a few hundred years ago, but that's been the continuing one. And one of the interesting one, I don't know if you know this, iron brew, which is a strange drink that people drink in Northern Europe, has managed to keep its secret recipe secret for more than 100 years. But other areas that can be subject to arbitration, of course, are breach of other kinds of contracts, including licensing agreements, distribution agreements, IP development agreements, and other forms of settlement agreement. And the remedies that apply in relation to IP disputes are not dissimilar to the remedies that apply in relation to other areas that fall under arbitration. So it might be injunctive relief, might be specific performance. Of course, there is also the fact that you're looking for damages or on accounts of profits if somebody's been using your IP without asking you. And of course, some other declaratory relief in terms of declarations of infringement or invalidity, or getting them to destroy the videos or whatever it is that you're seeking. So one of the interesting elements I wanted to actually talk about, and I'd be interested to hear from Josh as to what's happened in the US about this. And this is about TikTok. And so everybody will know TikTok.
Just came into my mind, oh my.
Yes. So the National Music Publishers Association, which is a US-based organization, represents thousands of music publishers and songwriters. They've threatened to sue TikTok for copyright infringement. But this, I know that I'm not sure where the US proceedings are at, but certainly this was preceded by a similar matter in the United Kingdom. So ICE, which is a joint venture representing a whole range of digital music rights societies, so those that have like Performing Rights Society for music in the US, and the GEMA, I think it's called, in Germany, and STIM in Sweden. They were actually faced with the same thing, and they had been negotiating a license with TikTok on behalf of the songwriters and composers and publishers that ICE represented. But when the parties failed to reach an agreement on the terms, TikTok referred the dispute to the United Kingdom's Copyright Tribunal, asking it to step in to resolve the matter with ICE. And this was about maybe a year and a year ago. And late last year, around December, I think the parties withdrew the dispute from the tribunal and agreed to enter into an arbitration agreement to agree the terms for TikTok in relation to licensing rights for music represented by ICE. And at the time, the parties released a joint statement announcing that the arbitration decision would be applied retrospectively to cover an earlier use on the platform. So we'll have to wait and see. Now, I was going to run through all the benefits of arbitration, but I'm assuming that most of your audience are aware that it provides for a cross-jurisdictional resolution of disputes. It provides for confidentiality, so it means that less risk to your reputation, your trade secrets remain secret. It is extremely efficient and it's enforceable all over the world through the New York Convention. But one point I did want to make in relation to the inadequacy or the unsuitability of patent infringement cases going to court is actually a case in which, so again, very old, 1892, Lord Isha, the Master of the Rolls in England and Wales, in a case called Unger and Sugg, where he blasted the use of litigation in such cases. And he said, apposite now, that a man had better have his patent infringed or have anything happen to him in this world, short of losing all his life by influenza, than have a dispute about a patent. His patent is swallowed up and he is ruined. Whose fault is it? It is really not the fault of the law. It is the fault of the mode of conducting the law in a patent case. That is what causes all this mischief. And I noted that in India, and again, Nilanjan can obviously deal with this, but I noted that the Delhi High Court in the Ministry of Sound and the Bombay High Court in Eros International Media said cases could be arbitrated, IB cases could be arbitrated. But I note that the Supreme Court has been a little less clear, and therefore India possibly lacks authoritative pronouncement at the moment in the sense that the Supreme Court hasn't specifically covered the issue. But I'd like to understand what's happening in India too. Thank you, Carlyta.
Nilanjan, you heard what she said on the last part of Eros and Supreme Court. I will be coming back onto that. And I must say, Ms. Rashda Rana, how wonderful, in such a wonderful, simplified way you have said about the mode of conduct, when I specify it. And you also described the copyright, the difference between the copyright and the author's right. And then you modulated the moral rights, the personal right, the right to be identified, right to privacy. And then you added a little grandeur on the Saturday Night Live. Viewers, I must tell you, Saturday Night Live is one of the most sought after television show. And if you really have to see that, please go and see. You will know what is right to integrity, right to privacy. All of them will come into this SNL, and you will get to know everything on this. So thank you so much, Ms. Rashda Rana. We'll be getting back to you. And you have given so much information on this vast work, what is happening in the United Kingdom. And of course, as you kept on saying, that has got so much of relegation with EU, which is the European Union. So I'm coming back to thank you once again, Ms. Rana, SA. And that brings me to the second speaker. That is Mr. Hulb Berndschot. I'm sure that I'm pronouncing her name, Mr. Hulb. Mr. Hulb Berndschot, am I right?
Yeah.
Thank you.
That's absolutely correct.
Is it correct?
Yes, absolutely.
Thank you so much. Yes. Hulb is a partner at the Benelux Law. Now, viewers, I must tell you what is Benelux, because this is, it is a member states which is an institute is compromised with Belgium and the Netherlands and the Luxembourg. So if you've got the B and the Ne and the Lux, so it's Benelux. So for the viewers, you must know that he's a partner at the Benelux law firm, AKD, where he has been since 2004. He specializes in soft international property, including copyright, and has extensively worked on international property with global corporation and represented them in several jurisdictions across the world and the globe. He's also a lecturer in various professional institutes in Benelux, which I already said it is the member state of the European Union. So the first question, as much there's so much and there's so much in relation to what which Mr. Rana has said, and there is a lot of similarity and a lot of compatibility, I'm sure. Okay, Mr. Hu, the copyright in Europe is quite complex, considering each member state country has their own specific laws and copyright, along with a supranational European Union law governing them. Could you please elaborate how the European Union
Yeah.
copyright law works? EU is European Union viewers. Thank you. Who, please.
Thank you very much, Carlita, for giving me that opportunity. And um, much of what Rana has said actually applies to the European continent as well. And while we speak, in fact, Rana and myself still sit within the European Union, and it's only a bit more than a week, and then we have sort of separated. Even though I guess we will continue doing business as much as before. Europe indeed is a little complex in the sense that it has 28 different member states and therefore also 28 copyright laws. And as Rana said, we've made an effort to harmonize large bits of the copyright laws, but the differences continue to exist. And I think making the comparison with Rana, she sits in a common law jurisdiction, whereas much of the European continent is Roman law based. And I think on a very abstract level, one could say that the Europeans tend to focus a little bit more on the property element, the rights of the author, the reputation and the name of the author, whereas I think in the UK, there's probably a little bit more emphasis on limitation also of rights, because ultimately intellectual property rights also limit competition. But it's on a more abstract level. Let me focus. I'm going to put the emphasis slightly different to what Rana has done, also to make a change for the audience. And let me look a little bit more at the relationship between the various makers or authors that create to a film work and the producer. The main rule is as Rana said, that in the land of copyright in the EU, the creator of a work is, so to speak, the king. And the author of a work, the one who genuinely creates the work, is in principle the author. And the rights, as Rana rightfully said, arise at the time of the creation, and it is not the idea itself, indeed it is the expression of the idea which is the object of protection. Again, also on the continent, no registration is required, albeit, and there I reiterate what Rana said, creation of a form of record to have evidence of the date of creation, to accurately determine your position as opposed to third parties possibly challenging you, is a very important thing. So if the proprietor of a copyright is the king, so to speak, and calls the decisions on the exploitation of copyrights, does the king have an easy life then in the land of film? And the answer is no, he hasn't. And the reason is that a film, as we all know, usually consists of the contributions of various creative persons, a director, a scriptwriter, cameraman, set builders, lighting artists, sound persons, music composers. Rana referred to them as well. So there are a lot of authors, creators that contribute, and that all of them can actually claim a form of right. But then in the land of film, there is ultimately also the producer. And let me explain a little bit on how it works in my jurisdiction and what I see mirrored in some other continental European jurisdictions. And be careful, I'm not saying this is not the situation in the UK. I'm just trying to put my emphasis slightly different. Because what the legislator has done is, in order to prevent problems about the control the various makers of a film, the legislator has created special provisions for film works. And why? Because the legislator wishes to avoid that the various makers may potentially frustrate the exploitation of the film. And whereas the interests of the joint makers are paramount, the interests of the film producer are not to be ignored. They're actually quite relevant. So who is the producer? The producer ultimately is the person that is responsible for the realization of the film work with a view to exploitation. His or her key objective will be the actual realization of the film, and here we have to be careful as to who is the producer. And the mere financier of a film or a client is not yet the producer within the meaning of the Copyright Act. As we have many contributors to a film, there is also the question, so what happens if a particular contributor does not necessarily finish the work or doesn't want to finish the work, or for other reasons defaults? Does that then cause a problem for the eventual exploitation of the film? And that's where the producer comes in, because the producer has the power to use an unfinished work from a maker to complete a film. And why? That is because the producer of a film has the right to eventually, and I'm very much talking about the Benelux jurisdictions now, has the right to decide when a film is ready for showing. And once the producer decides that the film is finished, he may then exploit also the various works that collectively create the film. Whether the film, for the benefit of the creator authors, the right of the film producer to determine when the film is ready for showing can be deviated from by agreement. And ultimately, I think I do want to stress the very important element of concluding the right agreements, even when you contribute to a film, and even when you are the producer. Unless the various makers, the contributors to the film, the creative minds, and the producer have agreed otherwise in writing, the makers are deemed to have transferred to the producer the right to exploit the film from the time of completion, and the time of completion is a call of the producer. So what rights have they transferred? Have they transferred the full copyright or possibly something less? And what they are deemed to have transferred is the right to, for example, to record the film and to publish the film. And that might include application of subtitles or dubbing of text. And it also applies to forms of exploitation that are not necessarily foreseen at the time of the completion of the film. There's a very important exemption here, and that is the maker of the film music and text associated with that music. They are excluded from the transfer assumption. So that's an important area to watch for anybody producing a film. Let me talk a little bit about the name and reputation, and then I will finish off, because otherwise the other speakers don't get a chance to give their perspectives. Rashda mentioned also the moral right element, and the law ultimately protects the name and reputation of the various makers, the various authors. And the law grants to everybody that contributes to a film the right to mention his or her name. And Rashda rightfully mentioned there is also a right not to be named if that would be a false allocation of effort. And the Dutch law quite specifically says that we always leave the cinema when the title roll starts rolling, even though the title roll contains very important and very relevant information, particularly from the legal perspective. If you contribute to a film, you've got the right to be named, and you have the right to demand that title roll is shown. It is not a hollow right. You must be referred to. And why? Because ultimately you want to contribute to a new film, and you want to be recognized for your effort and seen as relevant in the industry. Last but not least on this issue, and then I will stop here, Carlyta. Unless otherwise agreed in writing, each of the makers, never mind that they are presumed to have transferred the right to produce, to screen the film, they retain their copyrights into their part of the work. And if that work somehow is separable from the film, then they may actually disclose and reproduce these contributions separately, save that ultimately you must be loyal to the producer. So if that separate publication would actually be detrimental to or disloyal to the interest of the film producer and damage his or her interest, then you would not be authorized to do so. So key elements here, the right arises on creation. It's important to create a record of it, and agreements are an important element to construe your relationship with the producer or even between the various makers of the work. Those are important elements in the protection of copyright in the film industry.
Thank you, Mr. Hulb. That was a wonderful insight. And again, considering, when we go into the second one, is that in your long and illustrious career, you must have encountered complex court violations in the film industry, in the creative industry, as you have mentioned right now, the question of loyalty. What's according to your views are the best ways to protect the IPR in the film industry, specifically in the film industry? Because it's a broader zone, bigger amount.
Okay, the film industry, in a way, it is relatively simple because the expression of the idea is always, there is always a record of it, and keeping that record is important to determine your relation to other contributors to a movie, or the particular part you're responsible for. It's very important if you're with more creators to be very careful about the allocation of rights and to carefully record the allocation of rights. Who is responsible for what? Because if I look at the sort of disputes that I've seen over the last so many years, then some of them are about allocation of rights. Am I the creator, or did I just supervise this, and did I not lead the creative effort, and is somebody else the creator? Am I employed by somebody with whom I've got an employment agreement that says that the right does not really belong to me? And mind you, Rashda mentioned the moral rights, which are inassignable. But then somebody else might be the proprietor, your employer. So sometimes disputes go about allocation of rights. But then in protecting your right, it's also important to have a very clear agreement on the compensation of your effort and when that compensation may be expected. I've seen conflicts on those type of issues. To clearly agree whether or not your work is separable from the ultimately, I call it the collective work, the work stemming from the collective contribution of the various authors. Whether or not your work is separable from the collective is also important to agree, to know whether you're free to actually use or reuse the same work. And ultimately, it's important to be very clear on possible territorial restrictions. Is this agreed to for a single territory, for an economic union like the European Union, or even worldwide? Because those, in my experience, at least, that's where I've seen conflicts between various parties contributing to audiovisual works.
Thank you, Mr. Hulb. And when we were, as the question was put to, Ms. Rana, about the arbitration scope on infringement disputes on copyright works. Now, when we're dealing with the United Kingdom, and you're talking about Benelux, which is the 28 states. So how do you deal with this huge element of, how to, the arbitration, the scope of arbitration in the infringements?
I think Rana has given a number of very important clues, which I think I can only reiterate because they are so important. One of the important elements of arbitration is indeed, unlike a judgment from a district court, an arbitral award is easier to enforce. And Rana rightfully referred to the New York Convention, which plays a very important role in that. What might also be important is relationships between various authors might be delicate. And if you fall out, even though you do not want it, you may not want your dispute to be in the public domain, to be known in the street. And an important advantage of arbitration is that you can agree to keep things confidential. In principle, anything which is arbitrated is normally kept in confidence. And third, and then I will stop there. A third important element, I do find that if you follow the rules of civil proceedings and end up with the then competent court, it's not said that you end in a court where the judges necessarily have competence in the area in which you're asking a judgment. If you go to arbitration, you've got the ability to make sure that you get expert judges that know exactly what they're dealing with, that know your industry, that know intellectual property rights, and that's again a very important element in obtaining a fair judgment. Is there a disadvantage? Yes, there is, from my perspective, a distinct disadvantage, but many times it sort of disappears against the background of what I've just said. That is that arbitration may be expensive. You're essentially going to pay judges, and the paid judges will not move unless you've made an advance payment to them. That is on occasions a disadvantage, but I think many times the advantages sort of outweigh this particular disadvantage.
Thank you, Mr. Hulb. It has been a pleasure speaking to you, and especially when our viewers have come to know there are 28 copyright laws in the 28 states of the Benelux, and of course the main another thing which our viewers came to know is the expense which comes down, and that is very important. You have also mentioned the loyalty to the producer, which is also in connection to the moral right, which Ms. Rana has said. So thank you so much, Mr. Hulb, and we go into the third speaker, that is Mr. Nilanjan Sen. Welcome, Mr. Nilanjan. Thank you, Mr. Hulb. Thank you so much. Now, Mr. Nilanjan Sen is a counsel practicing in the Honorable Supreme Court of India and Calcutta High Court, and is a partner at Seven Seas Partners, LLP. Nilanjan specializes in commercial litigation, arbitration, and international property law. He represents film production to Bollywood media houses. Now, Bollywood is an Indian cinema, film festivals, and film professionals from both India and global. So, Nilanjan, from our understanding, the law of copyright is a centerpiece of legal work involved in the film industry. You have worked extensively for the Indian and international film production companies as a counsel. What are the problems you usually encounter when it comes to copyright in film industry, in Indian film industry?
Okay. First of all, many thanks to the organizers of Diorama for having me on this panel and for that gracious introduction. I'm extremely grateful. Your question, indeed, your question, in fact, starts with a very correct observation, which is that the law of copyright in India is, in fact, the centerpiece of legal work involved in the film industry in India. Now, having said that, I must add that this is just the tip of the iceberg. Owing to her creative heritage, India does in fact have a long-standing track record of staying committed towards protecting copyright of individuals. And this commitment has its roots to beyond the protections offered under the Copyright Act of 1957. While copyright protection in India is offered primarily through the Indian Copyright Act of 1957, her actions on the international level are exemplary, and they're reflective of a deep-seated ideology of protecting intellectual property of individuals through the process of copyright. And this is not just for its own nationals, but also it extends to international subjects, which I will come to a little later on. Now, why do I say exemplary and reflective of a deep-seated ideology of protecting intellectual property? And to answer this, let's run a quick history check. India's first step towards this direction was taken by her as early as in 1957 with the enactment of the Copyright Act. Now, this is indeed a holistic law. It's a self-contained regime because it defines the scope of what can be protected by copyright, albeit the fact that the scope of what can be copyrighted is rather nebulous in the law in itself. Our courts have nevertheless done a remarkable job at ironing out these creases. But that, I think, should be the subject matter of another detailed discourse on this subject alone, because I'm afraid we don't have a lot of time, and
Yes.
so you're going to start poking me shortly.
No.
What makes it truly exhaustive, and the reason why I call it self-contained, lies in the fact that it contains provisions defining injury of rights, as well as provides the remedy, both civil and, interestingly, also penal, and also lays down the process by which these injuries can be addressed by the people who are aggrieved. So, although late in this arena, India has done a lot. I'm sure I don't have as many pointers as Rashda would have, or as Hulb has pointed out in their respective jurisdictions, but India is making its mark in its own way. Now, furthermore, this is a remarkable piece of legislation, since it not only provides for civil remedies, as I said, in the form of damages and injunctions, and like Rashda here mentioned in the UK. But what is unique to it is that it is one of the very few which makes infringement of copyright a cognizable offense. What this means, and this is interesting because based on a fairly recent verdict by the Honorable Supreme Court of India, which was delivered in the context of the general criminal law of the country, and by virtue of which the police is bound to register what we call as an FIR, or a first information report, in the event someone reports the commission of a cognizable offense. So this being a cognizable offense, the moment someone goes and registers it before the police, no questions asked, a straight up police case and an investigation. And obviously, the Indian law does not empower the courts to have any jurisdiction over investigation. You get what I'm trying to get at. So by corollary, it even empowers them to make an arrest of an infringer if such person refuses and or fails to cooperate. Obviously, because of this, the police even has the power of search and seizure, and this includes seizure of the infringing material on its own motion, and without any intervention by a court of territorial jurisdiction. Furthermore, the Act provides that an offense of infringement shall be punishable with imprisonment for a term no less than 6 months, and extendable up to 3 years, with fine which shall not be less than rupees 50,000, which I think approximately is a little over 550 euros and about $670 US, and may even extend to 2 lakh Indian rupees, which is the equivalent of approximately 2,200 euros, and I'm being told about 2,700 US dollars.
No, you're right. Yeah.
Yeah. So now this was on the national level. And before I come to the protection of foreign works, I must stop and point out here that as a golden rule of international law, which all of my esteemed colleagues here who have been working on the international canvas would agree, is that international law trumps domestic law. Therefore, once a state ratifies a treaty, it cannot renege from her treaty obligations under the garb of municipal law. And Indian courts too are very well aware of this proposition, hence their proactive approach, which is visible through their repeated liberal interpretations to the various provisions of this bulwark of Indian copyright protection regime. If one were to trace India's international conduct, we see a remarkable degree of commitment on India's part since January 1975, which is when the Berne Convention was ratified by her. Subsequently, India renewed her commitment to protecting copyrights, and with periodic amendments till 2012, India has repeatedly attempted to respect her international commitments that she assumed while ratifying Berne. Now, another interesting fact which I would like to highlight here is that India's copyright law has a great degree of convergence with the 1995 TRIPS agreement, or the trade-related aspect for international intellectual property rights, as we know, now of which India has been a member for quite some time now. Apart from this, India is a party to various other international treaties, such as the Universal Copyrights Convention, the Geneva Convention for the Protection of Rights of Producers of Phonograms, as well as a member of the World Intellectual Property Organization, the WIPO, and the United Nations Educational, Scientific and Cultural Organization, which is the UNESCO. I was listening to yesterday's session, and I remember Mr. Honorable Justice Rajiv Bhalla as I had the pleasure of watching him speak, had mentioned the significance of these conventions in the context of an iconic Indian soap called Sarabhai versus Sarabhai, which has been
Right.
recreated by a Pakistani studio. But I'm not going to go into that again because that would mean repeating the entire narrative. Pardon me. So the point I'm trying to make here is that India is committed. The only thing is, having been doing this for some time now, I repeatedly find a marked absence of awareness among the creatives here in India, which is the only plausible explanation why intellectual property litigation is generally unheard of outside of the very few metropolitan cities. Now, putting this straight, the reason could be that they're simply not aware of their rights or how to protect their rights. This is sadly also the case with some of the enforcement officials. Without taking any names, I remember having come across a small-time artist once, a singer, to be precise. This person had a flair for lyrics writing also, who sadly was deprived of his claim to his intellectual property by someone who enjoys a fair amount of repute in the industry. Again, not taking any names. And I mean, interestingly, I happen to know both parties. So even after half a decade of the incident, this person, when he had the opportunity to share this with me, he had no clue about what he should do. That there is a regime that offers this protection. This person was sadly unaware. Pardon me. Now, coming to how the Indian regime offers protection for international work. Firstly, it defines work as an artistic work, be it a painting or a sculpture, drawing, including maps, engravings, photographs, architectural works, and obviously, of course, cinematographic film. Now, although the law per se does not mandate registration of copyright, as Rashda was saying, similar to UK, because it is no more than a mere recording of the fact, which does not ipso facto create or confer a right. Neither is it a prerequisite for going against an infringement. And obviously, being a member state and or signatory to many treaties designed to protect intellectual property in the international realm, works of foreign nationals are automatically protected in India through the International Copyright Order of 1999. And as I mentioned earlier, Indian courts have been very particular in the case of protection of copyright of foreign nationals. However, in my collective experience, it is always prudent to get it registered for two reasons. First, it is the only proof of ownership that is acceptable to the authorities, and it makes initiating action slightly easy. And secondly, since it is fairly inexpensive and costs somewhere between the range of 10,000 rupees to 15,000 rupees, which converts to about a little over 100 to 160 euros and about 135 to about $200. So the answer to your question is India's copyright law is a holistic law which defines the scope of the rights it tries to protect as well as the enforcement mechanism. And I hope I've been as crisp as possible.
I think that you had been superbly vocal about what you really wanted to say, and I'm sure it's very clear, crystal clear to the viewers and the panelists who are listening to us and you. And yes, again, coming back, Nilanjan, is that owing to your vast experience, in, again, in intellectual property counsel in the world and, of course, in India, what are the general ways and means you recommend through which IPR, the film industry, can be protected? Our Indian film industry, as you have seen, that a normal singer comes down and then she's lost, and the other person doesn't even know what's happening. So we are talking about this vastness of this Indian cinema.
Okay. Now, to answer this question, we must understand in the context of Indian law what can be copyrighted. Like the UK, the law provides that only the expression of an idea can be copyrighted, not the idea in itself. And the copyright vests in the person who creates it. What this essentially means is that copyright protects the work of an author, or let's say the creator, from being copied by others. It does not create an embargo upon the world from coming out with the same product through a completely divergent process. And I completely agree with this, because the main idea is to allow protection without hindering the free flow of ideas in society. For these reasons, it is imperative to understand how to therefore protect the idea. One of the ways is by writing it down, because otherwise it continues to be an idea against which no copyright can be claimed. Therefore, giving an idea a definite shape, such as by penning it down at least prior to submitting it to one of to someone. I think since the law acknowledges the existence of facts, it is written down text or an idea of the expression capable of being copyrighted. So basically, it is the form in which a particular idea is shaped which becomes subject of copyright, and this is on the same lines as the UK legislation.
Right.
Now, yeah, you were saying?
No, carry on, please.
Okay. So this was from the perspective of an individual. Now, speaking from the perspective of production houses. Now, one must understand how intellectual property coalesces with the film industry. This is something which one of the distinguished panelists in the last evening session also shared, if you remember, which is that the film production involves creation of intellectual property at every stage of production.
Correct.
Starting from script writing to music, set design, campaign, billboards, trailers, etc., etc. So from the genesis of the idea for a film to the final dissemination of the film to the viewer, intellectual property is getting created at every step. If, say, 200 people are involved at a particular scene alone, for example, in films such as, I'm talking in the Indian context, Padmavat, or let's say Hollywood, say a big budget movie as big as, say, Ben-Hur. Now, every individual involved in creating some form is creating some form of intellectual property. Now, which, unless protected, can be copied midway by someone else, and then you lose your money. So, as a production house, one must ensure that the entire chain of those rights, which are getting generated in course of filmmaking, belong to the production house and not to those 200 persons engaged in it. One of the ways a production company can do this is by having a carefully crafted work for hire clause in each contract for services or equipment that it engages. Now, this ensures all work created under a contract is owned exclusively by the production house. In fact,
you mean to say that production houses are hiring these 200 people, right?
Yeah.
These 200 people for the filmmaking.
Yes, exactly.
Correct? And then the production houses, they frame out different contracts for these 200 people.
Yes,
right?
that is true. Yes, that is what I mean.
So carry on. I can't. I can hear you now. Yeah,
okay,
carry
great.
on.
So, I mean, I remember while vetting some of these contracts for our clients, we often advise them to come for with separate work for hire contracts, and we often also come across completely self-contained work for hire contracts alone, but those are generally for more elaborate projects which have a lot of budget involved, a lot of people getting hired. So now there's also an indemnification clause. Film production not only involves the creation of intellectual property, but there's a significant amount of acquisition of licensing of intellectual property from third parties. This we all agree. Now, for example, in the course of marketing for a film, let's say multiple posters are designed. And now, not only is there a copyright being created on those posters, there are simultaneously also being acquired and are licensed by the production house, depending on the nature of the contract for marketing entered by these entities, be it the production company or the publication house. So let us presume that the publication house in a certain poster had earlier used a design which is used now out of the very many myriad posters that are being made for this one film or this project. Now there's always the possibility that the user of that earlier poster can suddenly resurrect and come to the production company and or the publication house. So it is essential that there must be an indemnification clause to protect either or both houses from opening the floodgates of litigation and its concomitant financial implications. If one was following the discussion again of last evening, I think you may have noticed that one of the panelists again gave this concept of indemnification clause.
I think Justice Rajiv Bhalla, and it was preceded by Siddharth.
Yes,
Siddharth.
I think Siddharth
Srivastava
in the context of acquisition of movie from recording studios.
Correct.
Now coming to the duration of copyright, now how there's a specific period. How long will this right vest with the owner? Section 22 of the current law provides that a copyright for works of individuals and which are published within the lifetime of the owner is valid for 60 years, counted from the year following such person's death. And for joint authorship, 60 years counted from the year following the year in which the author who dies last. Section 23 provides that in the case of posthumous publications and for anonymous pseudonymous publications, it will also, Section 23 to 29, I think, states that in the case of cinematograph films, sound recordings, works for government, public undertakings, and international bodies, the copyright shall subsist for a period of 60 years from the date of its first publication. Now, this, in my opinion, is some of the ways, many ways, individuals, production houses, as I mentioned and also as I mentioned in my reply to your earlier query, even foreigners can protect their intellectual property in India.
Thank you, Nilanjan. And then coming back, like I was asking, Ms. Rana, and then I asked Mr. Hulb on the national perspective, what's the scope of arbitration again if there is an infringement in the film industry, in our creative industry, when there is 200 people involved in a production house? Imagine there are thousands and millions films which are made in India, considering the regional.
I mean,
so that those infringement, how would you arbitrate that? I mean, the whole copyright works. Imagine the vast expanse of this huge industry which we have, which is Hindi, and several regional languages, and then you have got the tribal languages, and you've got sub languages, and
it's interesting that you point this out, although I'm a big fan of arbitration myself, because it's fast and a robust mechanism for resolving disputes. And like everyone else here said, that it has the advantages of confidentiality, flexibility, and procedure.
Right.
However, under the current scheme of laws, am I audible?
You are.
Okay, great. Under the current scheme of laws in India, as I was saying, our judiciary's approach on the subject matter of arbitrability, it can only arise out of contractual relationships. Under the circumstances, I think it's practically unfeasible, because it's rather impossible to create such relationships between an infringer or a possible infringer and the copyright owner. I believe, however, that such disputes are in fact capable of being resolved by recourse to arbitration, I think, as Rashda mentioned, in the UK and I think in Netherlands. However, having said this, I must remark that India also is moving towards this direction, however, in a rather nuanced manner. As very recently, the Supreme Court allowed arbitration in tenancy disputes in the case of Vidya Drolia versus Durga Trading Corporation. And now to answer Rashda's query, in the case of Eros, while it did involve the question of copyright, this was a case where there was a contract between the parties. So the court allowed arbitration as a contract existed between Eros and Telemax.
And that's the same thing happened with RK, the film RK, which was done by, and it was again Eros, and Ms. Rana Essie had been so correctly said that Eros is like a centerpiece of the legal viability of this IPR in India.
So sadly, since a contractual relationship is an absolute must for arbitration in this jurisdiction, without it, you cannot enter into arbitration. And in practice, however, on most occasions, the infringer also does not have a contract with like I said, with the owner. And therefore, I think arbitration in India right now, we still are a bit far away. Also, I can sense that this question emanates out of a sense of concern given India's ignoble track record of having an extremely slow machinery for the resolution of disputes. However, I do observe that with the creation of the Commercial Courts Act since 2015, the scenario is changing, and I think dispute resolution is much faster compared to what it was earlier. So, I think this. I hope this answers your query.
Yes, it is, and I'm sure the viewers are absolutely enjoying this. And I must say, Nilanjan Sen, that the very fact which you said about the IPA, the national perspective of international property rights in India, is that It's a long-standing. It has gone beyond 1957. You put it as a holistic law. Then you had this FIR, the cognizable offense, which is a little difference between the the international jurisdiction, as Mr. Hulb and Ms. Rana has said. And then you also said about the Indian copyright law with the TRIPS agreement and Geneva agreement. So it is India is coming. The national perspective of this international property rights is coming and getting onto it. So thank you so much, Mr. Nilanjan Sen. And with that note, we go into our fourth speaker, and I cannot say it's the last speaker because that's Mr. Josh Reinsberg. So I've already introduced you, and so I must say that Mr. Josh Reinsberg is an intellectual property attorney for over 14 years of experience litigating copyright, trademark, patent, infringement cases involving a wide range of products in art and digital media. Josh has practiced in state and federal courts against infringers on behalf of companies seeking to maximize their brand values by enforcing their intellectual property rights, and also those defending against such allegations of infringement. So welcome, Mr. Josh. And the first question I must ask you is that, as we understand in USA, again like EU, each state has separate laws with a federal law applicable to all the states of the United States of America. Could you please elaborate to the law of copyright in the US, United States in brief? How does the copyright law in each state works?
Well, thank you, Carlita, for that introduction, and thank you to the organizers for the honor of speaking with your audience. I don't want to sound like a broken record, but the fact of the matter is that as between India, the UK, and the EU, there is tremendous harmonization in terms of copyright laws, in part due to the convention called the Berne Convention and the TRIPS Agreement. So the Berne Convention signed in 1886, and the TRIPS Agreement became effective in 1995, which incorporated the copyright provisions of the Berne Convention, excluding moral rights. But in the U.S., you're absolutely right that we have a jurisdiction with 50 states governed by individual state laws, and then at the federal level, a set of federal laws. And generally, states do not have their own copyright laws. Copyright law in the U.S. is codified in federal law, which is enacted by the U.S. Congress, and Congress derives its power from the U.S. Constitution. And just like the U.K. and just like the EU, and also India to some degree, the U.S. Constitution encourages original works of creative expression. And as Rashda mentioned, an idea is not protected, but once that idea takes the form of a work of creative expression, that's where protection begins. And that is one of the fundamental precepts of the U.S. Constitution, because as a tremendous amount of research has shown, encouraging works of creative expression leads to benefits on a societal level and on an economic level. There used to be a time in the U.S. where state laws did have their own copyright laws, but that was mainly with respect to sound recordings published before 1972. Protection for those recordings weren't implemented in the most recent version of the Copyright Act that we have in the United States. But in 2018, the U.S. Congress passed something called the Music Modernization Act, which gave protection for these recordings until 2067. So generally speaking, we have one copyright law applicable to all 50 states. But that's not to say that judges around our country will interpret the copyright law in the same way. But as you can expect, the judges sitting in New York City, where I'm located, and California, the two hubs of the United States that deal mainly with filmmaking and productions that give rise to copyright protections, are usually the most knowledgeable. And that's where most of the litigation surrounding copyright law, copyright infringement, it takes place. And certainly courts in New York and California are the courts that are issuing the most precedential decisions on aspects of copyright law that lead to the evolution of our understanding of what Congress certainly intended in the Copyright Act and how it should apply today. But states do have separate laws when it comes to what I'll call IP adjacent issues that are relevant to filmmakers and producers, including the right to publicity and issues surrounding defamation, which can arise in the context of documentaries mainly.
Thank you, Mr. Josh. And the right to publicity was one of the very important part which you mentioned, because which is not very much evident, like the way it is in the United States of America, as you said right now. But again, coming back on to like Ms. Rana, Mr. Ho, Mr. Nilanjan Sen, they have, and you now, you also too boast of a long and a very challenging career, and you've encountered complex code violations in Hollywood, which is another vast entity of United States of America. So, again, what is according to your views that you can the best ways to protect the IPR in this film industry, which is Hollywood in USA?
Sure. By hiring a talented intellectual property lawyer, I'd have to say. As each of the distinguished panelists have mentioned, copyright law is very complex, and filmmaking is even more complex, and it involves a lot of individual contributors who themselves are entitled to a copyright. As Rashda mentioned at the beginning, copyright imbues at the moment of creation. If you write something down on a piece of paper that's a work of original expression, you are entitled to protection. That is your intellectual property. And the problem that studios in the U.S. as well as around the world, directors, producers, people who are actually managing the creation of a film, their complexity is actually ensuring that all of the copyrights held by all of these individual contributors are their rights. Because as Rashda and everybody else mentioned, IP is an asset. It's an asset with exclusive rights. You can prevent people from doing certain things with respect to what you created, including mainly distributing and creating derivative works. I mean, one of the most lucrative aspects of the Harry Potter franchise was not the books themselves, but everything that flowed downstream from J.K. Rowling's authorship, movie rights, merchandising. So usually the most lucrative aspects of a piece of intellectual property is not the original creation itself, it's what you can actually do with that. So to the extent that a filmmaker or a producer can hold all the copyrights, that's extremely important for investment purposes and actually creating a downstream monetary structure. But the issue that I run into almost in every case that I've dealt with is somebody who hasn't thought about IP protection until it was almost too late. So the best advice that I can give your audience is to think about protection very early in the development of your idea. Even though an idea itself is not protectable, you want to ensure that you have a strategy in place for ensuring the consolidation of copyrights, the registration of copyrights, everything having to do with intellectual property so you can preserve your monetization stream. And in the US, as I think in the other jurisdictions that are being discussed here, the key issue here is contracts. Contracts. Anything can be agreed to as part of a contract. And the things that relate to copyright law that need to be addressed in any contract are really two issues: assignment and indemnification. Assignment means that if you have somebody who's working on your film, who's contributing a work of original authorship, that person needs to assign their rights to you, the producer, the filmmaker. Because if they don't, they hold the copyright and then they can actually engage in distribution of their work. Now that can undermine the strategy of the director, strategy of the producer, strategy of the production house, and it can actually devalue your product. When all of your rights are consolidated in a single entity for a single work held by a studio or whomever, that provides tremendous value in terms of your ability to exclude all of the vendors who are working on your piece from actually trying to capitalize on the work that you're putting together as a filmmaker. So assignment is key. Indemnification is also key for the reasons that were expressed previously, namely that when you're licensing rights from others, you want to be sure that what you are bringing into your work itself does not infringe the rights of a third party. Because if you're using a work that is subject to a claim of infringement, again, that devalues your work. It actually puts you at risk for damages in the U.S. And that's a big part of our legal structure is the ability to collect vast sums as part of an infringement case. So contracts, assignment, and indemnification. And this, one other aspect, which is the concept of how foreign work apply in the U.S. This might not be something that is the same across all jurisdictions, but in the U.S., per the Berne Convention, you can sue for acts of infringement even if your work is created abroad. And I know that's true in other jurisdictions, but the quirk with respect to the United States, I believe, is the fact that if you create something outside of the United States, if your work is a foreign work and it's being infringed in the U.S., unless you've actually registered your copyright in the U.S., you can't collect what's called statutory damages. Statutory damages in our copyright law is a big deterrent because it allows you to go into court if you have a copyright and your copyright is being infringed and say to the court that you should collect something that the law says you should collect without actually having to prove the amount of damages. Proving damages in a court of law in the US is very expensive, very tedious. It requires expert opinions. It almost detracts from the amount of money that you can collect from a potential infringer. If you're going into a copyright infringement lawsuit in the US and you are not asking for statutory damages, it is going to be an expensive case. So you want to preserve that right. Now, how you do that is by registering your copyright in the US. So as part of this strategy, when you're thinking about the strategy for protecting your intellectual property as a filmmaker who might not be based in the US or is maybe not performing any work in the US, if you believe your work is going to be used in the US market, if there's value to the US market, then you want to register your copyrights in the US as soon as possible. And certainly before any infringement, because if what happens is you find that your work is being infringed in the US and then you go and register, well, that's not enough according to the jurisprudence in our system. You have to register your copyright before infringement to be entitled to statutory damages under the Berne Convention. So contract registration, that's what I'll have to say as kind of best practices for ensuring protection in the US.
Thank you, Mr. Reinsberg. And again, coming back, the question which I put across to all three of the eminent panelists today is that what is the arbitration scope on infringement disputes on copyright works once again?
Sure. It's fairly the same across the board.
United States, yes, yeah.
India, UK, EU, basically arbitration is a creature of contract. So in your licensing agreements, in your distribution agreements, anything that in any case in which you're working with another person to put together a bunch of creative works for purposes of a film, you will be able to include arbitration clauses, and assuming both parties agree, you can subject anything, any aspect of the agreement to arbitration, including issues of copyright infringement, trademark infringement, patent infringement. Any aspect of intellectual property rights can go to arbitration if both parties agree. Now, that said, some of the more sensational cases that you see in the media with respect to copyright infringement, it doesn't involve two parties who have agreed to a framework for commerce. This usually involves a situation where somebody creates something and another person believes that, hey, wait a minute, they have the copyright and they're entitled to damages. Well, in that case, usually you don't go to arbitration because you don't have a situation where both parties are agreeing. But, an arbitration clause in any contract as part of the filmmaking framework should be included because it's less costly than a court system. And you can actually select your arbitrators and select individuals who are most knowledgeable in the specialization that you need to adequately address your dispute.
Thank you, Mr. Josh Reisberg. It's pleasure again when we keep on hearing, when the viewers are listening to all the 3 and 4 different aspects of IPR. But it's so wonderful that it's so internally connected. So coming back, that you have said that the strategy to ensure one's copyright. You mentioned about the assignment, the assigned rights. You mentioned about the indemnification, the statutory damages, and the registration. One has to register in a very simple way. One has to register the work, the international property, to ensure that it is defended. Thank you so much. Again,
Yeah.
I must say thank you so much to our first speaker, Ms. Rana SC, to Mr. Hu, to Mr. Nilanjan Sen, and of course, Mr. Josh. Huge thanks from me, our viewers, on behalf of 2020 Diorama International Film Festival. And another must say that wish you and everyone a blessed Merry Xmas and a COVID-free, blissful and lawful and peaceful New Year 2021. Thank you so much.
I would also like to thank you everyone for
Thank you,
this
Carlyta.
Thank you,
informative
Carlyta.
session. It will definitely help a lot of young filmmakers, studios, directors, producers, legal
Yes,
professionals all over the world. And it was an honor for us to invite you all to this session. And I thank you,
absolutely,
Ms. Rana,
absolutely.
Hulb, Nilanjan, Josh, for your time. And thank
They're
you, Carlita,
brilliant.
for moderating this
They're
session
brilliant.
wonderfully.
I mean, I'm
I wish you
sure
all the
that
best.
today when I see it's going, the whole chart is like it is getting a chart buster today. It's IPR chart buster. It's happening. So everyone
I
have a
wish
great
you
time. Mhm.
I wish you all the best in Merry Christmas and the best of luck for your future endeavors. And a Happy New Year.
Thank
Bye
Thank you
you.
for
bye
this.
Same to you.
bye.
Thank you,
Bye, Ms.
everyone.
Rana.
Thank
Bye, Mr.
you. All
John.
the best.
Bye,
Bye.
Mr. Ho.
Bye.
Bye, Mr.
Bye.
Nilanjan Sen. And I'm going to
Bye.
catch you soon, Kunal.
Thank you. Bye bye. Good night.